YouTube, it's Tone back with another one for you, and this one here today is a continuation of the court survival guide. This is the fifth video on that. There's probably a few more left in here. Then I'll find another one for you actually, because I can see the feedback from this shit is pretty good. So you guys are looking for this info, so I got you. So look, so let's get into the rest of this here, because there's some pretty good stuff in here. So what do we got? So at the end, we were talking about the judges being honest about the jurisdiction that they were trying to charge you under, and you need to know which jurisdiction it is in order to set up a good defense. So this is where you will win. Right here it says the judge must either lie or dismiss. The truth is that they have just committed a statutory to a statutory jurisdiction, and there is no such thing, not to mention no official public rules to use. In some cases, the judge will make faces at the prosecutor, and the prosecutor will motion to dismiss for some phony reason. Either way, you win, and that's how it'll end up being. They'll just dismiss it on some technical bullshit, when in all reality it's because they had no other option. But it is what it is. A win's a win. So see diagram. So alternate plan B. This is where the judge has actually answered truthfully back at the question 2. And however unlikely this may be, you must be prepared to go the distance. The judge has now admitted that the criminal action will be brought as a condition of contract under the criminal aspects of admiralty jurisdiction. Here is where you will be digging into the very origins of the fraudulent admiralty jurisdiction, i.e. the fraudulent international money contract that Roosevelt signed back in 1933. So picking it up at the third outcome to question 2, would you then say, or you would then say, thank you, Your Honor. Let the record of this court then show that this court intends to proceed with a criminal action against me, XYZ, which is you, as a condition of contract under the criminal aspects of a colorable admiralty jurisdiction. Is it still not dismissed? So then question 4, Your Honor, you must realize, and this is a question, but you see how it's formed in the it's formulated as a statement, but then you just, you throw a question mark on the end of a statement and it turns that shit into a question, apparently, right? So, Your Honor, you must realize that no courts in America have admiralty jurisdiction without also having valid international contract in dispute, because admiralty jurisdiction is all has to do with contracts. So, am I not aware of having and I'm not aware of having entered into any international contract, so I deny that any such contracts exist. Now, will you instruct the prosecuting attorney to inform this court that there is a valid international contract in dispute, if there is one, and to place this alleged international contract in evidence if it does exist, and explain how I can be a party to it if I am, and how I am compelled to perform under it if I am. And so this is the thing. So basically, you're putting them into a position where they're gonna. So you're pretty much calling it bluff, right? So initially, you come in. You need to know the what do you call it? The nature and cause of the action that's being brought against you. The action, right? Because they're all actors, so they can only bring actions against you. So you need to know the cause and the nature of the cause of the charge that's being brought against you in order to stage a good defense. Now, you already know that these people are operating fraudulently, so what you're doing is basically backing them into a corner to where they have no way out. They never had a way out, but they didn't know that. Or maybe they did, but nobody called them on it. But you are. So you need to know the cause and the nature. They're going to end up backing themselves into a corner to the point where they have to admit the fact that they're operating under admiralty jurisdiction, which means that it's all contract related. It's commercial in nature, essentially, is what it comes down to. So now they're going to have to prove that there does exist a valid contract. And even if there is one that exists and you got hooked on through some adhesion contract from some other bullshit that you signed, and that was the whole reason that they were fucking with you to begin with, well, that shit is a snake ass move. And even if it is valid, a freaking adhesion contract or whatever, if they were to actually verbally articulate the scam that got you involved and somehow hooked onto a contract with them, they would just look like the fucking snakes that they are. So they really can't say the stupid ass reason why they have you in there, but you're gonna make them say that shit on the record, and they can't, and they won't. I mean, why are they gonna why are they gonna do that? So this is an opportunity for the judge to bail out and let the prosecutor go down in flames. They're so stupid. They're so dramatic. So this is an opportunity for the judge to bail out and let the prosecutor go down in flames. Technically, it is the prosecutor who must prove jurisdiction once it is challenged. And it's true, because it's the prosecutor that's charging you, and then the judge is just sitting there as the mediator. But I mean, really, they're all against you, but this is the game that they play. And those are the roles that they're supposed to be playing, right? So it's pretty much you against the prosecutor. So you want them to prove that shit too, but also the court, right? So now she is in the hot seat. At this point, the judge will probably dismiss, or the prosecutor will move to dismiss, or you may get a smart but foolish full historical explanation of admiralty jurisdiction from the prosecutor. He or she might unwittingly spill the beans and get fired later, because this is the big secret that they don't want the people to know. They can't afford to let us know that our country has been bankrupt since 1938, that the bankers own everything, and that we are all held compelled to perform under admiralty in default of paying off the phony debt that Roosevelt racked up. No problem, they're going down for the full count. If this happens, you can reply, fine, let the record of this court then show that the court has declared that a criminal action against me, XYZ, is a condition of international contract under the criminal aspects of a admiralty jurisdiction, which is commercial in nature, which brings you right back to where your remedy would lie, and that would be inequity if it's a commercial venue. So that's why you need to clarify in order to be able to get this shit done properly. So next, still not dismissed, huh? So announcement 3. Now, Your Honor, according to the law merchant codes, which is this would all fall under, because admiralty is going to be contract, commercial, merchant law, right? Maritime law, the law of the sea, and so they bring it onto the land. Mind you, this is the water world, so I kind of do feel like it does kind of freaking apply somewhat, but they be forcing it with the whole maritime shit. So the very law that this contract was made under, there are certain things that constitute a valid versus an invalid contract. You must realize that no court has the authority to enforce an invalid contract, and I deny that the validity of this contract that Roosevelt entered into with the international bankers. He borrowed bank credit on the promise to redeem in gold coin, creating credit out of thin air. The bankers had no risk and no interest, because they didn't loan anything of value, and thus had no interest in the loan being paid. It was a no-interest contract, and thus void by the international law of nations. Therefore, America owes no legal debt. This is not to mention the fact, this is my personal opinion. So, it's not to mention the fact that we are all dealing with debt, fiat currency at the moment anyway, and probably for as far back as history goes. And you can just discharge all that shit anyway. It's just debt. And you just, it's all just about keeping the books, essentially. So question 5, and now, since America only owes the debt by an invalid contract, and something else with that, I already put on my page that if the nation is in debt, they could just send me the bill for the nation, and I'll go ahead and discharge that shit for them, and we can end this nonsense and this fuckery once and for all. You know what I'm saying? So if it's really just an issue of debt, just send me the bill. What's the problem? You know what I mean? And now, since America only owes the debt by an invalid contract, how am I, as an American citizen, legally compelled to perform under an invalid contract under the admiralty jurisdiction of this court? So you're getting all this shit on the record. You take this shit to fucking appeals, and they're just gonna want to get that off their desk ASAP. So staying with the plan, you must contain the discussion within the plan. When you get to a corner question, when you get to a corner question that the judge that the judge answers improperly, i.e. away from the plan or issue, you must repeat or emphasize the issue that gets the argument back into the plan. So this is where you defeat any of the judge's lame excuses and keep him or her in a corner. This is where you adapt your questions to stay in control. This is where you must know the strategy inside and out to a point where you really know how it works. Accepting the win. So when the case is dismissed by whatever means it is achieved, you have won. It doesn't matter that they lied about it or made up phony excuses for dropping the case. It doesn't matter that you have been insulted or that justice wasn't truly served. It's a win. And it doesn't get any better than this with the current system. Smile and leave quietly. And that's a win. You know what I'm saying? You're not gonna have these people apologize and admit to being fucking pieces of shit and all that. They're not gonna do that. Not to mention the fact that they're just doing their job. You know what I'm saying? A lot of these people probably really can't do anything else. I mean, you see the competency level of some of these people. I really don't think that they can do anything else. So they're doing what the fuck they came here to do. Appreciate that. You know what I mean? So, and take the wins as they come. And they do come with losses too, mind you. So stop here. If you understand that you have read up to this point, and if you understand what you have read up to this point in this guide, then you know that the rest below might not apply to your case. We are offering the remainder for the sake of the completion and to document and to share our own personal experience. You should be able to win your case with the mastery of what is given above. If you are strongly interested in the remainder of this guide, then we presume that your case has already proceeded past arraignment and you are flailing for solutions, and you are a hardcore patriot masochistically immersed in the court system for the education and experience. And some of us do that. I mean, you know, I like to learn the hard way too, you know. So strategy 2, and I mean, I do learn the hard way. Let me just put it like that. I like to when I do. So this is a way, albeit less successful, to soften up the judge before the hearing so that you will appear more personable and less confrontational in court, and so that the judge gets a small idea of what he or she is up against before being put on the spot, i.e. on the court record. This also gives him or her another way out of bringing formal charges against you. Here, you deliberately schedule some friendly quality time in conference with the judge at your request to discuss some questions about the upcoming hearing. You are going to politely inform the judge that he or she is at grave risk in allowing the case against you to continue, that you could be bluffing, but the judge needn't know that. This way, the judge has ample opportunity to find a way to dismiss your case without losing face and his or her illusion of authority. Illusion of authority. Okay, and so this is true too as well too. So you can also have the courts operate in a what the hell is that thing called? Oh, a chancellor. So you can have the judge operate as a chancellor. Is where you'd go in there and meet him in his quarters personally, and then work out any details of the case privately. And you may even be able to settle the matter privately with him acting as a chancellor. Right, so look into that. See what we got here. Okay, so make an appointment to see the judge privately. Oftentimes they are happy to receive any visitors beyond business as usual. And I mean, I've done this too, like years ago, before I even knew any of this shit. And so when you meet, you know, you go meet with the prosecutor and shit like that, talk about your case, you can usually get that shit thrown the fuck out, because they're used to just seeing people, and not even seeing people, just looking at cases, papers, numbers, and shit like that. So when you can actually get in there and speak with these people, you know, most of the time, nothing against them, but, you know, most of the time they're fucking cowards and shit. Like, a lot of the fear that we have toward these people, or have had or may have toward these people, is all in your head. They're just regular people. And, you know, they just, I mean, a lot of them are really just doing their job. So you can get in there and talk to them personally and work something out a lot of the times. That's just real. So what do we got here? So make an appointment to see the judge privately. Oftentimes they are happy to receive any visitors beyond business as usual. Ask the judge to read the last sentence of UCC 1-103.6, which says that the code cannot be read to preclude a common law section mentioned with thoughtfulness, that the judge may even be open to a liable suit for violating your rights under common law by using the wrong statutes against you. At this point, the judge will know that you have a remedy of recourse, and that all you need to do is make a reservation of rights as described below once you get into the court. So now you say something like, Your Honor, I will be exercising that remedy, and you will have to construe the UCC in harmony with the common law, and you will have to come forth with a damaged party, or you will be personally liable for the damages. So if they can't serve up the person that's making the accusation, because under common law you're gonna have a injured party, then the cases are gonna have to be thrown out. But you have to lock them into a certain jurisdiction instead of assuming that they're operating under the one that you think that they are, or even the one that they say that they are, off the record. You know what I mean? So This could admittedly be a bluff on your part. You may not even consider suing the judge, but this is only a small glimpse of the embarrassment that judge could face, and he or she may easily get the message to dismiss your case at once, especially if it's a corny case. So strategy number 3, win by default. In any appearance, if your accuser or the officer does not show up, you automatically win. The judge will have to dismiss the case because there is no witness against you. And I mean, there is no witness anyway, even if it's the state against you. Really, who the hell is the state? You only ever have a administrator representing the state that ever comes to argue any points against you. You never actually have the state that comes through. So that alone is a pretty good defense, I think. So all you have to do is point out the officer's absence. You go home free, and the officer gets yelled at, not your problem. But since the court makes millions of dollars upon these traffic cases, you cannot always depend on using this strategy. The officer usually shows up. So strategy 4, challenging jurisdiction, second best plan. So this is a good strategy for use right up front as you open your mouth for the very first time in court before you even mention anything else. Here, you're going to challenge the court's authority to even hear the case according to the body of law which the court is legally allowed to govern. This technique will allow you to take, if necessary, the action into a district court where you will be allowed to argue constitutional issues, but ideally the court will want to dismiss the case before it even gets that far. As always, there is a risk of being charged with contempt of court because the judges have all taken a secret oath never to reveal the true jurisdiction of the court, i.e. admiralty jurisdiction. But then you can always come back with, what court? I'm sorry, but I recognize no authority here but my own. That's a fact. So he says, so what court? Because I don't see one. And I'm sorry, but I don't recognize authority here but my own. Now you're going to put these people in a position to go ahead and have to explain and prove that they even have any authority to begin with. They don't fucking have it. So, but it is better to be very polite about it. So here's the time and place to use the next best general strategy. Here's the drill. So when you appear to supposedly enter a plea, you instead walk right up, place your American flag on its stand, and present the judge with 2 written notices. See Appendix. One notice is a notice of special visitation and of foreign law, which establishes you as a foreign entity to their fraudulent system of law and your God-given right to argue the constitutional issues. The second notice is a judicial notice of military flag and challenge of jurisdiction, which is a direct challenge to the fringed flag, military symbol of authority, and the military jurisdiction that they are trying to pull over on you. The prosecutor has the burden of proving jurisdiction, and he or she will have to lie, cheat, and or violate to do something about it. Nail them, right? So you will have to modify the example form. So it looks like there's probably a default form in the back here, and do a little research, such as finding the state's equivalent of CRCP 441, e.g. Colorado Rules of Criminal Procedure, and the CRS Title 24, e.g. Colorado Revised Statutes. You must present these notices and enter them into the court record before you say anything about your particular case. Make your stand on these 2 notices by insisting that neither your case nor the law nor the accusations may be heard until these 2 overriding issues are resolved, and sit on them. Right? You're going to have to put these people in a position to freaking acknowledge your documentation. You know what I mean? Because otherwise they're going to just try to roll right over it and fucking act like they never even seen that. Which I'm sure is what they do with a lot of the fucking paperwork. So here, you will not speak of anything nor participate in your case until the prosecutor has legally completely proven that the court even has jurisdiction over you. Of course, you already know that that is impossible, but they will just try to intimidate and disempower you for challenging their false authority, and they will try to haul you off to a private room off the record so that no one else will hear the truth of their fraud. So you can tell them that you are prepared to go to trial, there are 2 issues alone, and that you insist on putting them into the court record, and that you will present as much evidence as it takes to expose them. Make them sweat and embarrass them into dismissing the case. I mean, you got to see the last letter that I sent to the courts. I mean, I posted it on my page. I might even post it again. The shit's fucking horrendous. It's rude as fuck, ridiculous, way out of line. I wouldn't even recommend anybody sending this shit, but I did. And you know, it had a lot of this shit in it. And the jurisdictional overuse just not there, you know what I'm saying? So that shit is crazy. So make a photocopy. And I mean, the last time I was in court, well, The last time I was in court, there was for like driving or some stupid shit like that. It was years ago. It ended up being two gentlemen that were in there. They switched out like five judges throughout the court case, and they called me up last, and it was only me in there, and then it was just two judges were there. But I mean, it wasn't judges. They didn't even have like the black coats on. It was just two regular Jewish dudes in button up shirts just sitting there. They sent the lawyer off into the cage where the prisoners usually come up from the bottom floor. They threw the lawyer into that cage, so he was off the plane. And then it was just me standing there with two dudes in these button-up shirts, and they were just real calm, nonchalant attitudes and shit. And so because they saw the paperwork that I was trying to file for the case probably like 2 weeks prior to that, so they already knew that something was going on. And I was too shy and new to all this information to even have a stand to begin with, so I just kind of rolled into the fucking regular proceedings with these people. But I saw what it is and how things change when they know that you know a couple things and shit, and the courtroom environment will be different, and more than likely it will only be you in there. So keep that in mind. So make a photocopy of the two examples notices mentioned above and doctor them up with your case number and other such details. Be sure that there is nothing falsely stated on these notices when you present them. You should only have to appear once, but if you are not dismissed right away, repeat this strategy every time you appear in court. If all goes well, you will not have to dig any further nor do any more with your dismissed case. Prepare and notify your two notices similarly to those shown in the appendix. The first notice establishes your legal basis for arguing any constitutional issues in the next higher district court. The second notice specifically challenges the fraudulent nature of the court's jurisdiction. All further strategies will depend on this one, so make it good. Set your flag up where everyone can see it in the judge's face. If you have to go gung-ho. So there are some backup notes for your artillery shells. So Higgins versus Levine, 415 U.S.C. 533 N-3 Note 5. Once jurisdiction is challenged, it must be proven by the plaintiff. So Owens versus City of Independence. The mere good faith assertions of power and authority jurisdiction have been abolished. So you can also use the missing plaintiff argument to further expose the court's error if the prosecutor attempts to bluff his or her way through by shooting down your written evidence with lame verbal excuses. Remind the judge that the prosecutor still hasn't proven anything. Motion, ask, and or demand the judge to order the prosecutor to prove jurisdiction with hard evidence or drop the charges against you. Get the case dismissed, i.e. motion for dismiss, because the jurisdiction has not been proven. Strategy 5. Refuse to recognize the plaintiff. This is perhaps a fallback strategy if strategy number 1 above is not working here. You simply stand on your Sixth Amendment right to know the nature and cause of the action against you. So when they ask you if you understand the charges against you, you say, no, in fact, I'm not even sure that the plaintiff is even present. Or if the judge asks you if you are ready to proceed at any court appearance, repeat those words again. So the point is, the cash register courts and DAs all fraudulently impose their laws and accusations upon us under the color of law, which is bogus. They presume to represent the people of your state. They hide behind that title and then expect you to feel intimidated and guilty for offending the people. In reality, they represent the corporate state, the banks, under the false extension of the corporate of the United States, the foreign banks. It is you who really represent the people, because the charges arise from the law which require that the people's compliance without their consent. So the laws are really based on, look, they wouldn't have to get your consent to rule over you, which they do have to get your consent. They wouldn't have to get your consent to rule over you if they really had that type of power. They would just fucking do it, wouldn't they? So they're trying to snake you into giving them the fucking consent for a reason, because they don't have it otherwise. So make them prove that they have that shit, because their actions really show and prove otherwise. You know what I'm saying? Because I mean, anybody can say anything, but it doesn't look like it to me. Like you have that power that you say you have. So after all, weren't you simply minding your own business to begin with without injuring any party? This system is deliberately dysfunctional, and the people are paying for it. So in this strategy, you must also stand on your 11th Amendment right to be protected from their foreign jurisdiction, because they are certainly not representing we the people, and it is you that is a member of the sovereign body of the state as a de jure member of we the people. So study the Constitution and the Black's Law Dictionary definitions of plaintiff, injured party, foreign state, foreign interest, nature and cause, etc., then you will really understand how their whole illusion and ballgame rests upon you giving your consent to their fraudulent representation of the case against you. Bring photocopies of everything to court and demand that the prosecutor produce a legal and legitimate plaintiff, or else the case must be dismissed. So strategy 6, challenge the ticket. Use this if you know that there is some technical error in the way the ticket is filled out. Ask to compare the original with your copy. For instance, something could be spelled wrong. A number could just be one digit different. The state or the time of the stop could be wrong. You may have written something else in that renders it null and void. The original may have been altered after you signed it. The officer may have filled in false or misleading information, such as entering phone number refused instead of none. Your correct address could be misrepresented. The officer may have written something on the back of the original evidence, which has been... And so something else to keep in mind is that they always need an address from you, right? So this is why I just use the passports and things like that, because it doesn't have an address on there. Or if you do give them an address, give them a fucking foreign address, that one that they don't have one that they don't have jurisdiction over. You know what I mean? Play the game, just play that shit right. But they do need an address to tie you to commercially, residentially, because everything is commercial in nature. So if they don't have an address, they really don't have a fucking case. So the office, because I've dealt with that, because I don't give them an address, and they'll just go and try to use the last one that they knew I had and shit. And it's like, bro, I didn't give you an address for one because it's none of your fucking business. So I don't even understand how you could even be sending me anything. Right? If you want to be clear, if you want to be real, my address is none of your fucking business. So you shouldn't have it, and I'm not gonna fucking accept any of your offers here to an address that I didn't even give you. You're out of your fucking mind. So the officer may have written something on the back of the original evidence which has been withheld from you. Be a good detective. Any such mistake renders the ticket null and void for cause. And that is a good cause to freaking reject that. So strategy 7, plead ignorance. This is one of the easiest overall methods we've learned to date because of its simplicity, effectiveness, and minimal confrontation. Here, when you are asked to enter a plea, you say, Your Honor, I thank the court for extending an opportunity to get an attorney, but I will defend myself propria persona, the proper person. And I apologize for my confusion, but I just don't know what my rights are, so I ask or demand that my birth certificate be placed in as evidence so that I may proceed according to my rights. So this puts the judge on notice and saves his or her face on the record. Of course, you realize that you must be willing to follow up on whatever the judge rules. By law, the judge must allow your birth rights and your birth date to be admitted into the record now that you have requested or demanded it, because so far there is no written proof of the court's jurisdiction over you. The judge may try to intimidate you by warning you that a jury is required to establish birthright evidence. Of course, this is just what you want. The judge will have to bluff in some other way to avoid doing this. The judge now has an opportunity to dismiss the case in order to prevent you from exposing the truth and the court's fraud in front of the jury. If a trial date is set, then you have plenty of time to file a series of notices and demand letters, or other legal instruments requiring jurisdictional compliance, and then recuse the judge for not complying. Details in the following sections. At the very least, you may postpone the trial date for greater than 6 months from the date of citation. This entitles you to dismiss the case on the basis of violating the Speedy Trial Clause of the Sixth Amendment. So strategy 8, challenging the judge's status. Low probability of success, but possible. This is a strategy to use when the judge asks you about getting a licensed attorney, but before you decide to represent yourself pro per, the fact is that there really is no such licenses. So that's the thing too. So the judge is merely trying to intimidate you into losing the game and or paying more into the fucking nonsense. So, you're going to tell me to get a fucking licensed attorney, bro. So prove to me that a license even fucking exists. How would I go about finding a licensed attorney when they don't fucking exist? So he's trying to send you on a fucking witch hunt. And if you go and try and do that shit, they already know that you're all set. All the way set. All the way set. So what do we got here? Yeah, so the system by paying the attorney fee. So all attorneys and judges, including the court-appointed defender, are members of the bar associations, which are nothing more than elitist clubs ordained by the foreign banks under foreign titles of nobility. Strictly speaking, unless they have renounced their bar membership and title of nobility, they are all foreign agents committing treason against the U.S. citizens of the United States. So you can use this in your favor as well as follows. So thank you for upholding my right to hire a licensed attorney, Your Honor, but I have failed in my extensive research to find any attorney with a license, so that in order for me to comply with the court's advisement, may I please see your license, so that I will know that what an attorney license looks like. And if the judge pulls out a bar attorney card, he gets kicked the fuck off the case, because you can't be a bar member sitting on the bench listen and hearing a case at the same time. It doesn't work like that. So if he tries to prove that dumb shit, and this is me telling you that, so if he tries to pull that dumb shit by pulling out a bar card, then he's already off the case, because so he's disqualified at that moment, because you cannot be a fucking bar member and sitting on the bench hearing an actual case like that. So. And also, that's not even a license. So it's just a membership. It's a private membership card, as a matter of fact. So what is it? So it says, may I please see your license so that I will know what a attorney license looks like. The judge will surely be sweating bullets now and may even dismiss the case outright, or you may get some excuse that the judge is not obliged to show you anything. If this happens, then politely hang in there and carefully shoot down the judge's lame excuses with more questions like, oh really? So has the court made a judicial determination that the judge may preside over my case without being a licensed attorney? Or, oh really? Has the court made a judicial determination to deny my Sixth Amendment right to a licensed defense attorney? Or will the court kindly place in evidence any valid attorney's license so that I may know how to identify a licensed attorney? Or has the court made a judicial determination that I must find a licensed attorney according to the court's rules without the court first defining what an attorney license is? Okay, you get the idea. Good. Be nice, but don't let the judge off the hook that easily. The only risk you take here is the contempt of court ruling from the judge. Be prepared to deal with this factor just in case. Right? So strategy 9, challenge under common law, marginally successful. So you would also use this at the very beginning when you first open your mouth before even giving your name. This strategy indirectly implies that the court's jurisdiction is out of order, and you have to combine this with another strategy which forces the court to identify or approve the jurisdiction. You essentially assume common law jurisdiction with the questions up front, and then carefully watch how the assumption fails. Your purpose is to dismiss the case by exposing why the court is failing to comply with the common law jurisdiction. So you would start by asking, where is the injured party? Ask the judge if he or she is the injured party. Ask the officer, ask the prosecutor, ask anyone in the courtroom to come forth as an injured party. Embarrass them into default. Verify with the judge that you are in fact the accused of being a criminal. Then announce, well then, Your Honor, by the rule of corpus delicti, which means the injured party, I move that the case can be dismissed. I move that the case be dismissed for lack of injured party. Some prosecutors might argue that the state or the people of the state XYZ is the injured party. This is where you must argue that the corporate state of XYZ cannot lawfully participate as an injured party in this case, then demand that the evidence supporting the prosecutor's claim. So then you can point out that you yourself represent the people in this case, because it is the people that are held liable for the statutes in question, and you inform the judge that since the prosecutor is falsely claiming to represent the people, that his or her claim against you is void for fraud, then ask the case to be dismissed for fraud. Now the key word here is fraud. You know what I mean? So, and you know what's funny about that is that, so fraud is a commercial term in general, and the term came from the Federal Reserve Bank, and it's the Federal Reserve Act, the whole fucking fraud thing in general. And who the fuck you think's really the ones committing the most fraud? The same people, the same people that made up the word. So get the fuck out of here with that. So look, it is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Till we meet again.